Hello, I'm Dave Smith and welcome to our program. Now today we'll be discussing Canadian legal aspects of security. In this first installment, we'll provide you with an overview of the law in Canada as it pertains to you as a security officer. Now we will cover what the law is, sources of Canadian laws, the types of law that you should know about, and the court system in Canada. Now our instructor today for this program is Dave Ray. Now he is one of Canada's foremost specialists in corporate security. Dave is the Director of Western Canada for Kroll Associates, an international security company. He has spent 14 years in the Royal Canadian Mounted Police and 22 years specializing in corporate security. Let's join him as he presents the Canadian legal aspects of security.
Now, what is the law? Many attempts have been made to apply a verbal description to the word law, but there is no universally applied definition. It's used to describe a wide variety of precepts. Specific statutes, the justice system, scientific principles, such as the law of gravity, institutions, as in officer of the law. For our purposes here, laws are rules governing society. They're everyday guidelines that govern our behavior. They stipulate our obligations to each other. They set penalties for breaching those obligations. They establish procedures for the enforcement of those obligations. Let's talk about the sources of our laws. We'll look at three areas from which our present laws are derived. Firstly, the common law, secondly, precedent or case law, and lastly, statutes. Okay, firstly, the common law. Before the introduction of a justice system in England, feudal lords resolved disputes amongst the commoners, and there was an expectation of consistency. Later, royal courts were established and judges discussed their decisions to ensure some consistency, but it was not set down in statutes. Canada adopted the English system of common law and in 1953, with amendments to the Criminal Code, codified all offenses of the common law. The Criminal Code did not do away with common law defenses or procedures, and they continued to play a significant role in the Canadian justice system. Some of the common law defenses, such as insanity, compulsion, and self-defense, were included in the Criminal Code. Second, precedent or case law. I mentioned earlier that decisions by judges of the royal courts in England were discussed to ensure their consistency. Today, decisions are recorded case by case, and the principle that a court must stand by previous decisions is entrenched in a doctrine known as stare decisis. It evolved out of the common law requirement that courts honor earlier court decisions. The doctrine is simple, but in application is more complex, often putting both parties in a position to offer precedent to support opposing arguments. A judge must undertake several considerations to decide the weight to be applied to any previous decision. Firstly, the age of the case, the jurisdiction of the court where the decision was made, the level of the court where the decision was made, the similarity of the facts, the reputation of the judge rendering the decision, and whether there were any dissenting opinions of that court. In Canada, civil law has two different meanings. In Quebec, civil law is the body of statute law called the Civil Code and the Code of Civil Procedure. It is based on the Napoleonic Code, and that was established in France. It is still largely private law, but most of it is codified. Quebec is referred to as a civil law province. In the remaining 9 provinces, civil law is also largely private law, but very little is written into statute. It is based on the common law, that is, case law, along with common law actions and procedures. The provinces other than Quebec are known as common law jurisdictions and territories. For our purposes in this section, we'll be addressing civil law in the common law provinces. The third source are statutes. Statutes are the printed law. They've been adopted through government legislation at the federal, provincial, or municipal level. The British North America Act, or BNA Act, delegated power to the federal and provincial government to pass laws governing the people of Canada. Provincial governments in turn may delegate power and authority to municipalities within their borders and to tribunals. Federal statutes are laws that are applicable to all of Canada and all Canadians. They may be passed to ensure revenues, to run the country, or for the public good. Examples of federal authority under the BNA Act include things like banking, criminal law, and shipping. Provincial statutes are laws passed by the Legislative Assembly of any province and apply only to that particular province. They include authority for things like hospitals, natural resources, and the administration of justice. Municipal statutes are known as bylaws or ordinances and are created for peace and good order within the boundaries of the municipality. Examples are things like parking and pet control. Tribunals are given the power to administer rules of conduct to specific identifiable groups of people. For example, professional societies like the Law Society are self-governing in terms of their professional activities. Okay, let's talk about the Charter of Rights and Freedoms. The Charter of Rights and Freedoms is federal legislation that was passed in 1982 when the Canadian Constitution was repatriated. It generally applies to the police and the courts and how they conduct their business with us as members of society. It applies to relationships between citizens and government. It does not apply to the employment relationship, and it does not apply to personal relationships. Only the legal system. It provides rights in relation to search and seizure, detention and imprisonment, arrest, self-crimination, and right to counsel. In order for there to be a breach of the Charter, it must show that the administration of justice was in disrepute. It does not impose a sentence or fine for a breach, and it provides sanctions regarding inadmissibility of evidence at trial, disallowing evidence gathered in a breach of the Charter. The Charter has an effect on the security profession in 4 areas. Firstly, arrest, the right of security officers to arrest in the course of their employment.
Good afternoon, sir. How are you doing?
Pretty good.
Can I speak with you for a minute?
Sure.
Okay. Do you have anything on your person right now that doesn't belong to you?
No, not that I know of.
Okay. Do you understand that if you did have anything on you right now that would didn't belong to you, that would constitute theft?
But I didn't take nothing.
Okay. Well, I've seen you sticking objects in your jacket from the store there, so if you'd like to come with me, please. I'm placing you under arrest.
All right, but you're wrong.
Secondly, search, the employer's right to search employees, their lockers, personal effects, such as lunch buckets and purses, and other searches in the workplace. Next, confessions, the right of an employee to counsel in being questioned during a company-initiated investigation.
Do you have some identification, sir?
Yeah, I do.
And next, drug testing, the effect of the Charter in respect of drug testing. We'll talk about drug testing in a minute. The other items will be covered later in the program. Let's talk about human rights legislation. There are many misconceptions about the Charter of Rights and Freedoms and the human rights legislation. While the Charter generally applies to police and the courts and how they conduct their business, human rights legislation applies to how we conduct our business as employers. Human rights legislation relates to discrimination under one of the protected grounds, and it therefore applies to us as employers and employees. If we discriminate against an employee, we offend human rights legislation. The Canadian Human Rights Act was passed in 1976. As a federal statute, it applies to departments and agencies of the federal government, crown corporations, and businesses governed by federal jurisdictions like banks, airlines, and railways. Most jurisdictions prohibit discriminatory practices based on race or color, national or ethnic origin, religion, age, sex, marital status or family status, and conviction for an offense for which a pardon has been granted. It also includes physical or mental disability and sexual orientation. The provinces also have legislation regarding human rights. They're generally referred to as a Human Rights Code, Human Rights Act, or Individual Rights Protection Act. Although they vary slightly from province to province, they all generally prohibit discrimination in property rights, such as purchase and tenancy, in employment, including wages, hiring, and the right to belong to employee associations. Both federal and provincial statutes provide for a tribunal to hear complaints, investigate, and enforce the legislation. Some provide for sanctions against hate literature. These tribunals have very broad powers to award damages or order the company to create policies, provide training, or other appropriate measures. Human rights legislation is having a growing impact in our society. Human rights statutes govern both harassment and treatment of employees with alcohol and drug abuse problems, as well as the employment relationship. In a 1992 Ontario case, McKee versus Hayes-Dana, that was heard by the Ontario Human Rights Board, a company was downsizing and laid off an older supervisor while keeping a younger one. Rather than sue for wrongful dismissal, the laid-off employee complained to the Human Rights Commission. His case was successful, His award was his salary from age 57, when he was terminated, to age 65, when he would normally retire. This is significantly more than he would have received if he had sued for wrongful dismissal, and his notice period had been increased. Harassment, as I said earlier, harassment falls within the provisions of the human rights legislation. Some provincial statutes address harassment specifically, while others address it under the grounds of the type of discrimination. In the province of Ontario, sexual harassment has also been accepted as a health and safety issue. So an aggrieved person can make an application to the Labour Board and to the Workers' Compensation Board for damages.
What do you think of my girls?
That's really inappropriate.
You can be one of my girls?
That's really unprofessional.
Do you have anything like this?
You're sick. I want another locker.
Any act of harassment committed by an employee or agent of an employer in the course of the employment may be considered to have been committed by the employer. This means that the employer may be liable for acts of harassment either at the workplace or away from it, during normal working hours or after normal working hours, so long as the acts are committed within the course of employment. The term within the course of employment is not always clear and therefore may be subject to interpretation. Most human rights commissions provide a very broad definition of harassment, generally including verbal abuse or threats, unwelcome remarks, jokes, innuendos, or taunting about a person's body, attire, age, marital status, ethnic or national origin, religion, etc. Displaying of pornographic, racist, or other offensive or derogatory pictures, practical jokes which cause awkwardness or embarrassment, unwelcome invitations or requests, whether indirect or explicit, or intimidation, leering, or other gestures, condescension or paternalism, which undermines self-respect, unnecessary physical contact such as touching, patting, pinching, punching, and physical assault.
So you want to go out with me tonight?
No.
Come on, we have a good time.
No, I already told you I don't date guys I work with.
We can go see a movie, maybe get something to eat.
No, I told you. How many more times you can ask me before I decide to cross the line?
So you say yes and you find how much fun it is.
I'm not going to say yes here. You're making me uncomfortable. I don't want to work with you. I don't want to be around you, okay? I'm going to take this to Glenn if you ask me any more here.
You're not going to take it that far, are you?
Yeah, I will. I'm going right now. See you.
Sexual harassment is unwelcome behavior which is sexual in nature and adversely affects or threatens to affect a person's job security, prospects of promotion or earnings, working conditions, or opportunity to secure a job, living accommodations, or any kind of public service. Now we'll talk about drug and alcohol testing. Federal and provincial statutes do not specifically prohibit drug testing, but human rights commissions have interpreted the physical disability section of the legislation to include discrimination based on the disability of addiction to alcohol or drugs. The Federal Human Rights Commission established a policy outlining its position on drug testing. The policy links drug testing with identified safety needs and with a bona fide occupational requirement for safety. It recognizes a need for testing to refer employees to employee assistance programs and recognizes the procedures outlined by the Addiction Research Foundation as a minimum standard for testing. In order to reduce substance abuse, employers may institute a substance abuse policy, utilize employee assistance programs, investigate incidents of suspected violation, institute training and awareness programs, and in some cases, employ drug and alcohol testing. So far, we've addressed what is the law, sources of our laws, common law, case law, and statutes. We've also introduced you to the Charter of Rights and Freedoms and human rights legislation, specifically covering legislation relating to harassment and drug and alcohol testing. Now we'll move along to the types of law that you are most likely to be exposed to in the security industry. We'll also talk about the court system in Canada and rules of evidence. Let's explore the different types of law. Firstly, criminal law. Criminal law is established to protect the public good and not to provide a means of retribution for the victims. Crimes are investigated by the police and handled in court by a Crown prosecutor who is paid by the state. Prosecutions are made on behalf of the state and not on behalf of the victim, and if found guilty, the accused may be required to pay a fine to the government, serve time in a government jail, or report to a government probation officer. The role played by private security in respect to the criminal justice system is as follows. Firstly, investigation. Obviously, they may investigate. Seizure. Their powers of seizure are limited. Arrest. They may make a citizen's arrest. Charges. They rarely lay charges except as a private prosecution. And lastly, prosecution. And security people rarely prosecute except as a private prosecution. Criminal offenses include offenses under the Criminal Code and any offense under a provincial or federal statute. They can be summary conviction offenses, indictable offenses, or dual procedure offenses. Let's talk about summary conviction offenses. They're considered to be less serious. In the U.S., they're called misdemeanors. Summary conviction offenses include all provincial statutes such as Traffic and Liquor Act, and they're heard by a lower court. Examples are an indecent act or indecent exposure, disturbing the peace, prowling at night, or peeping Tom type offense. Now let's discuss indictable offenses. They're obviously the more serious infractions. In the U.S., they're called felonies. There's basically three types of indictable offenses. Those which must be heard by a lower court, such as theft, false pretenses, fraud, and mischief. Secondly, those which must be heard by a higher court, things like treason, mutiny, piracy, murder, or bribery of a person holding judicial office. And lastly, those which the accused can elect either a lower court or a higher court. They include offenses such as robbery, arson, secret commissions, etc. With dual procedure offenses, the Crown may elect to proceed either by way of summary conviction or by indictment. The offenses are deemed indictable until a prosecutor elects how to proceed. Examples of those dual procedure offenses are theft, over $5,000, mischief, unauthorized use of a computer, assault, fraud, false pretenses, and sexual assault. Okay, now the civil law. You'll recall that criminal law was established to protect the public good and not provide a means of retribution for the victims. Civil law, on the other hand, is the area of jurisprudence related to the relationships between individuals and other entities, such as corporations or government. The purpose of the civil law is to protect private rights and not public rights. It is the individual who has been wronged and who must undertake the civil action. He must pay for his own lawyer and hire an investigator if one is required. Any award by the court will go to the victim and not to the state. It's not unusual for an action to result in both civil and criminal proceedings. For example, if a security officer was assaulted, the police may be called in to investigate, and the person may be charged with a criminal offense. Since the criminal court may not recognize personal damages or losses to the security officer, he may sue civilly for damages from the assault. Both cases may proceed at the same time, although through a different court system. The person responsible may be sentenced to jail by a criminal court in order to pay the security officer damages by the civil court. There are three major areas of the civil law. Firstly, those that protect the private rights of an individual and have not been legislated by statute. For example, torts, contracts, and trusts. Secondly, those that are quasi-civil in nature because they protect the rights of an individual but are governed by statute. Example, corporate law, family law, and property law. Third, those that are cross-jurisdictional and cover both criminal and civil law. Examples are security law and environmental law. We will specifically address areas of civil law that have a direct impact on security officers in Part 2 of this training session. Now let's talk about labor law. Labor law establishes and enforces the relationships between an employer and an employee. Again, simultaneous actions may take place from the same set of facts. For example, if a worker assaults his supervisor after an argument at the work site, he may be charged with an assault in criminal court. The supervisor may initiate a lawsuit to recover damages for medical expenses or lost wages, pain and suffering, and the worker's employment may be terminated. As a result, we may see simultaneous actions, firstly, a criminal charge, secondly, a civil suit, and thirdly, an action by the worker in a civil court for wrongful dismissal or in an arbitration hearing if he is a member of a trade union. Labor law governs the third scenario, where someone is challenging discipline or termination of their employment. The function of labor law is to enforce the employment contract on behalf of the parties to the employment agreement. It is handled by management and the union or their counsel. It results in a court award or an arbitration award. The chart that you're looking at highlights the differences between criminal, civil, and labor law. The function of criminal law is to protect the public good, whereas civil law is there for private compensation. The function of labor law is to enforce the employment contract. Criminal law acts on behalf of the general public, civil law on behalf of the private parties, and labor law acts on behalf of the parties to the employment agreement. Criminal law is handled by a Crown prosecutor. In a civil law action, it's counsel for the parties. In a labor law action, it's management for the union or their counsel. The results of criminal law is a fine or imprisonment. In civil law, it's damages or a court order of some kind. In labor law, there is a court or arbitration award. Next, administrative law. Administrative law falls within the broad umbrella of a civil law, but relates specifically to the rules governing the relationships between the government and its citizens. It's identified as the body of principles and rules stating and governing the functions and powers of all agencies of government concerned with the application, working out, and practical administration of government policy. The area of administrative law is becoming more and more important with the development of a number of tribunals and regulatory bodies that govern the functions of private citizens and business in Canada today. An example within the security industry is the existence of provincial bodies that provide licensing and regulation of the industry. Administrative law principles would apply where someone was turned down for a license or where there was an application to revoke an existing license. Tribunals have broader powers than the courts, and for that reason, administrative law principles are important to define those powers. Tribunals have broader powers of rules of interpretation, powers of entry and inspection, powers to compel release of information, available remedies, and prosecutorial discovery. Consider, for example, the broad power of fire inspectors to enter and inspect premises, the powers of human rights tribunals to order companies to create policies and training programs, and the rights of Revenue Canada to demand documents and records. The major issue in administrative law is how far, by what means, and in what circumstances will courts intervene to control or overrule a tribunal. When a tribunal arrives at a quasi-judicial disposition, there is a fairness test that must apply. It may not be contrary to the Code of Natural Justice. Natural justice in this case simply means fair play. Let's talk next about the court system in Canada. There are several levels of courts in Canada, both within the provincial and the federal court systems. Firstly, the provincial courts. Provincial courts exist on three levels. The first level, lowest, covers a variety of minor, civil, and criminal matters, typically including small claims, provincial court, surrogate or probate court, family and juvenile court. In some provinces, these specialized courts are part of the second level of courts. The second level has unlimited jurisdiction. Courts in this level may be referred to as Supreme Court Trial Division, Superior Court, High Court, or Court of Queen's Bench. The third level and the highest in each province is the Court of Appeal. It's also called the Supreme Court Appeal Division or Supreme Court Court of Appeal. It hears appeals from the second level of courts and various administrative tribunals. The second system is the federal courts. The Federal Court of Canada has a trial division and an appeals division. The trial division has jurisdiction over matters concerning suits against the federal government, copyright, patents, trademarks, bankruptcy, shipping, and navigation. The appeals division hears appeals from the trials division. The Supreme Court of Canada is the court of final appeal in Canada. It consists of a Chief Justice and 8 judges. The panel at an appeal may be anywhere from 3 to 9 judges, depending on the importance of the matter being heard. The right to have an appeal heard is not automatic, and it is necessary to apply for leave to appeal. Before we close, let's look at the topics that we've covered up to this point. As an overview of the law in Canada, we've provided you with an explanation of what the law is, the sources of our laws, including common law, case law, and statutes. We specifically talked about the Charter of Rights and Freedoms, human rights legislation, harassment, and drug and alcohol testing. We covered criminal law, civil law, labor law, and administrative law. And lastly, we gave you an overview of the court system in Canada. That concludes our program, and thank you for joining us.
Well, that concludes this installment of Canadian Legal Aspects of Security. Thank you for joining us, and we'll see you next time.